Okay, good morning. Welcome back to day 2. I am very excited to be hosting this panel this morning. We are the panel on the role of competition policy in mediating the crisis. So I'm going to start with really brief introductions of folks who need no introductions, but I'll go down in any event in alphabetical order. We have with us today Elettra Bietti. Professor Bietti is currently a joint fellow at NYU and Cornell Tech, and will be starting this summer as an assistant professor at Northeastern School of Law. Prior to joining academia, she was an antitrust lawyer at Allen & Overy in both London and in Brussels. We also have Renata Hesse. Ms. Hesse is a partner at Sullivan and Cromwell, where she co-heads their antitrust group. And prior to that, she led the antitrust division at the Department of Justice as acting assistant attorney general. Professor Singer, Hal Singer is with us. He's a professor of economics at the University of Utah and the director of the Utah Project. And he has testified and served as an expert in many matters, including most recently serving as an expert for the FTC. And last but not least, Professor Yu is the John H. Chestnut Professor of Law, Communication, and Computer and Information Science at Penn Law, where he is also the founding director of that institution's Center for Technology, Innovation, and Competition. Professor Yu frequently testifies before Congress and recently served as a member of the FCC's Broadband Deployment Advisory Committee. So without further ado, I think I'd like to kick off before we go through questions that I throw out to the panel by noting our unique position toward the latter part of this conference and the title of our panel, which as I mentioned is the role of competition policy in mediating the crisis. To note that our title assumes that there is a crisis. And in our time together yesterday, we heard lots of esteemed folks make the case that indeed there is a crisis of some sort or other. And I'd like to start by asking our panelists if they agree or not, and why, and if so, in what sense. And I'll start with Renata and then open it up. Thanks.
Great, and thank you. It's great to be here. This is my first time at the conference, so it's very exciting for me. So I guess I would say I'm not sure the internet's having a midlife crisis. I think maybe all of us are having a midlife crisis about the internet being midlife. And maybe that's perfect for me since I'm an old person. So, you know, it all seems to me pretty natural that the, as Tim just noted, the internet's been around for quite a while and is middle-aged. And I think it's taken on a role in our lives that many of us both welcome and don't welcome at the same time. And I think, you know, as a panelist yesterday noted, that the internet surged at a moment when other support systems, particularly for kids, which is where she was focused, had really receded a fair amount. And the digital platforms have become, I think, very powerful as a result. And I think that scares a lot of people. And to me, that fear of the digital platforms actually just intuitively makes sense. As I said, technologies change the way that we live in good ways and in bad ways. I don't actually love being reachable 24 hours a day. I would prefer not to be reachable at some points of the day. Now, I shouldn't probably be quite so glib because some of the concerns that average Americans and citizens in other countries have, and the political power that's really amassed in order to do something about the power of big tech, I think will have an impact on the technology companies themselves and the platforms. But what kinds of changes the political forces in the US in particular can reach consensus on remains really unclear, to me at least. But the Europeans are moving, both at the EU level and at the member state level, and the states are moving as well. And those movements are going to change, I think, the relationship between technology companies and all sizes, not just big technology companies, and government. And I think they will start to feel regulated in ways that they haven't really up until this point. I'll just, as an aside, I'm not a person who buys into the idea that the technology companies have gotten a free pass for the last 20 years. I think there's been a lot of work that's been done in that area. And Tim did not mention US v. Microsoft, which I think if you're gonna do IBM, AT&T, you kind of have to think about US v. Microsoft as a technology-focused antitrust action designed at that time to really open up the operating system space. And I think that had some very good, you can call them industrial policy effects on the technology space. But this is not a country that loves regulation, at least in our history. We aren't big on regulation. We've had periods of time with significant regulation. And at least in my experience, the antitrust enforcers haven't thought of themselves as regulators. It was interesting listening yesterday to people saying the regulators in the US and the regulators in Europe. The antitrust folks at the division and the FTC don't call themselves regulators. They're really about law enforcement. At least that used to be the case. And I think part of what we're seeing in the antitrust space is a shift of that kind of thinking, or at least a push to change that view, for the US to be more receptive to regulation, again, at least in the technology space, to engage more in industrial policy in the way that Tim described, much of which I agree with 100%. And for the enforcement agencies to be more involved in the economy in a way that looks more like, and sometimes actually is. So you can talk about the non-compete rulemaking, proposed rulemaking at the FTC is something that really does look like, and I think is regulation. But the wheels of justice don't move particularly quickly. And so that process, at least if you're going to rely on the antitrust space to solve some of these problems, and my own view is that many of these problems can't be solved by antitrust, then that's going to take a long time, and I don't think we're going to see a lot of regulation. But I love the question that Tim asked at the beginning: what shakes things up? So I'm hoping we'll get a chance to talk about that.
Great. Any other thoughts on our crisis?
Okay, I'll go. You want to go down in order?
Yeah.
I'll address that, and I appreciate how you're kind of keeping us on our toes. I was expecting a different first question about the role of regulation, but hopefully we'll get to that.
Yeah.
But I first want to just thank Blake for inviting me. It's very gracious to have me here, particularly in light of the Twitter spats that we've had over the years, including over the news bill. But it's very gracious for you to be here and magnanimous, and I should do the same when I'm constructing my panels at Utah. Maybe I should invite some Chicago school defenders or consumer welfare standard defenders for the next panel. On the crisis, I'd just say that I don't like that word. I think it should be reserved. I'm personally going through a midlife crisis, as evidenced by the car I'm driving. And I think, a crisis is if my barista screws up the heart that she makes me in the morning. I mean, that's a personal crisis. But I don't think that we should use the word crisis to motivate policy or legal opinions. I don't think you'd want your economist at least to go into a courtroom and start screaming crisis at the top of his lungs. And I wouldn't do the same in front of Congress as well. So we have problems, and we have problems that need addressing. Hopefully we'll get into some of those. But I want to kind of leave the word crisis out of the discussion if we can.
All right.
Okay, so I'll put a plug for the crisis. And so I was looking at at some Google search results on midlife crisis. Hopefully I'm not yet there. But so some of the causes of midlife crisis are apparently the maturation of children. And clearly some of the internet's children, early startups, have matured. And then another cause is physical changes associated with aging. And Here too, if we look at the internet, the morphology of the internet has changed dramatically over the last 30 years approximately. So we went from a very decentralized space that was celebrated for being extremely free and emancipatory and that afforded egalitarian relations between individuals and small businesses, toward today an internet that is primarily controlled and dominated by a few commercial actors and then all sorts of other smaller for-profit actors. And so as a result, our experience of the internet has changed from an internet that perhaps included some pockets that were immune from profit logics to an internet that is today, in the words of Charlie Warzel, soulless and monetized to death. So I would argue that there is a midlife crisis here.
So we're in an academic institution. And so the question immediately wants me to go where Tim wanted us to go with the other question. How do we think about this? I mean, it's easy to talk about crises. I mean, we love to blame things on Cambridge Analytica and Mark Zuckerberg and now Elon Musk. But I think that that's a bit too easy. I mean, if you actually, the empirical work on the election say that Cambridge Analytica had no impact whatsoever. And so, you could plug that hole in the dike and you still have a raging problem. So in a way, that's sort of a substitute for analysis and a substitute for real solutions. And also, I think there's also a lack of a sense of history. Someone once said, every generation thinks it invented sex. And so we have this whole idea. And I'm thinking, economic power, things like the railroads back in the 19th century weren't a big problem. Media, William Randolph Hearst in the earliest 20th century wasn't a big problem. They had tremendous control over lots of things and they created their own responses, but sort of I still remember, so when Tim and I started teaching, 1999 was my first year. The big thing was the AOL Time Warner merger. And everyone acted like it was the end of history. It was actually just the end of $200 billion in Time Warner shareholder value, which is not a policy problem. We're not here to save people from catastrophic business mistakes. But I mean, there's a tendency, now I am feeling like a midlife crisis. Once you've been doing this long enough, God, I sound like an old man. You see this stuff come around where, it does seem like that sometimes. And so what it seems to me is we should think about this. The other thing I'll throw, I was asked to write on the 40th anniversary of the Journal Telecommunications Policy. I was asked to write a retrospective. So I flipped back and I said, 40 years ago, what were our issues? Monopoly voice, triopoly television networks, and emerging worries about a monopoly multi-channel telecommunications distribution via cable. All three of those problems are solved. And they were big problems. And so what's fascinating is just to get a little bit more framework on it. What I plea is, if we're gonna call it a crisis, let's develop a framework. And in the spirit of flattering Silicon Flatirons, there's a fantastic article published by Shane Greenstein in this journal, where people were worried about innovative health. And he actually said, let's create an analytical framework for diagnosing when a market is innovatively healthy. And some of them, are still raised as concerns, but two of them were looking for economic experiments and vigorous standards competition. And many people would look at the standards competition and say, that's a sign of a problem, that's a monopolist trying to take over. And Shane said, that's a sign of a vibrant industry that's kind of pushing at its limits. And so taking a step back and figuring out how to think about this in a little bit more objective and systematic way, instead of responding to headlines and anecdotes that make great sound bites, I think is what universities ought to be doing.
Great, thank you so much. So I want to turn us next to talking about a theme that we've seen come up a few times and some pushback against that theme. So I'm interested to see sort of what the panelists think. This notion of techlash, right, or this backlash against big tech with something of a contemporary resurgence of interest in that sort of thing. And we've also had a few participants here and panelists. We had Julie Brill yesterday mentioning, hey, these problems are real, but also we should think about all the wonderful things that have come as a result of this technology. And Orly Lobel, who came and did a faculty colloquium for us on Fridays, also got her new Equality Machine book out. And she presented a bit about AI for good, I think is what she's calling it, which is sort of saying, you know, we're all so hunkered down on all the bad things that AI is doing that maybe it makes sense to balance that out with all of the advantages that AI might provide us. So the question I'd like to pose is about this contemporary backlash against big tech and whether it's well-founded or potentially well-founded. Are large platforms like Amazon, like Facebook, are they really monopoly concerns? And if so, what's the proper regulatory response? And I'll turn to Hal and let him kick us off there.
So your question, you raise this phrase, monopoly concerns. And let me just start right off the bat saying that antitrust really doesn't have a problem with monopoly per se. You know, monopoly is a predicate for harms, but we're actually looking for the bad act, you know, where a firm leverages its monopoly to engender some kind of competitive injury. And I'd point out that even regulation, like something you might consider radical, like structural separation, if we were to hypothetically require Amazon, for example, to sever off its merchandising arm, even that would condone its remaining monopoly in e-commerce. So I think that monopoly by itself isn't really the problem either for antitrust or regulation. Now, your question also concerns Facebook and Amazon, and for delicate reasons, I'm gonna just ignore the word Facebook for now, else my handlers would be very upset, other than to say they're a terrific company. But with regard to Amazon, you know, I think that there are some possible pathways there for antitrust to provide the solution for the problems that Amazon poses. For example, I think that Amazon's tying requirement that requires merchants to take Amazon's fulfillment service as a condition of getting access to the platform is something that's ripe for antitrust scrutiny. I think that Amazon's use of MFNs, most favored nations clauses, that prevents merchants from offering discounts to customers to go buy their wares at a lower cost platform is ripe for antitrust scrutiny. There's economic literature that explains how MFNs wielded by firms with monopoly power can engender all sorts of horrible things. Now, regarding the proper regulatory response, I have a thesis I'm going to try to sell you on, and that is this, that I think that regulators should limit their interventions to those areas where antitrust cannot reach or where antitrust gets in the way. So let me try to give you some examples. Antitrust can't reach the harms flowing from self-preferencing, in my opinion, which is why I support the self-preferencing ban. Now, economists have documented that independent merchants tend to exit Amazon's platform after Amazon clones the product and then steers searches to the clone. But I don't think that evidence of rival exit alone would be sufficient to prevail in an antitrust case where plaintiff's economist must show a cognizable harm, typically from the consumer's perspective. You know, just imagine sending me into a courtroom and explaining to the judge that you can't see the price effect now, Your Honor, but trust me, in a future period when there's fewer merchants on the platform, choices will be degraded and prices will be higher then. I don't think that's going to go down well in antitrust court. Moreover, antitrust tends to give great deference to conduct that stays within the firm's boundaries. And so when Amazon engages in self-preferencing, there's no contract. It's not conduct that escapes the boundaries that involves, say, an external supplier or a client. And for those two reasons, I think that this area, this notion of self-preferencing is very ripe for regulation. Now, when the conduct in contrast goes outside of the firm's boundaries, as it does in the Google Play Store case, and big disclaimer here, I'm the consumers and the state's expert in that matter. I'm a bit partial. But here you have conduct that clearly goes outside of the firm's boundaries. The plaintiffs are alleging that Google put exclusionary terms in contracts with OEMs and with the mobile carriers. And when the harms are measurable in the short run, I think that it falls squarely within the ambit of antitrust, and I don't see a need for regulation. And it's why I'm a bit ambivalent as to these two bills in Congress right now. One would compel Google and Apple to allow merchants to use third-party payment systems, and another would try to break apart the ad tech structure. I feel like in both of those cases, the conduct there and the types of harms that are being discussed or being alleged are much more amenable to antitrust scrutiny. And in that case, we should lean more heavily on antitrust. And then finally, I promise I'll surrender the mic after this last point. I said another condition is for regulation is when antitrust gets in the way of good outcomes or competitive outcomes. And so here I point to the newspaper bill as a good example of a case that's ripe for regulation. We know that if any individual newspaper were to try to demand a positive payment from Facebook or from Google for the right to access the newspaper's content, Facebook or Google could easily just slap them away. And that's why the market price, given that tremendous power imbalance, is always going to be zero. I realize that makes a lot of people probably in this room happy. But if you're a social planner or you're worried about what the returns are to investing in the news industry, that's troublesome. And so the idea behind that bill, there's more to it than this, but the primary idea is that we would grant an exemption to the news publishers so that they could bargain collectively. And who knows, maybe collectively, the balancing of the power in that bargaining game might result in a positive payment for the rights to access the newspaper's content. And that would be something that I think most economists would recognize as being closer to the competitive price as opposed to zero, which I don't think is the competitive price. And by way of disclaimer, I should say too that I wrote about my support of that bill before I was retained, but I ultimately was retained by the News Media Alliance. So I just thought I should get that on the table too.
All right, I'll go. So when I think about this discussion about the techlash, you know, I'm always feel compelled to start where I think Julie started, which is to say, you know, technology has done a lot of good things, and I think it's important to acknowledge those things and to be aware of the positives that technology has brought to our lives. On the other hand, I also think we need to be clear that it's not like the technology companies are curing cancer, right? It's, you know, we're making it easier for people to find things and buy them, to find people, to share things, and to make certain things in life more efficient, and to solve some social problems, proximity to grocery stores, telemedicine. I mean, there are lots of things that tech companies have made much easier that have really improved the lives of people. But again, we're not, you know, we're not curing cancer. And I think part of the problem, the reason why we see so much angst and anxiety around the tech companies, but relatively little actual action in terms of Congress. The antitrust agencies have brought some litigation recently, some unsuccessfully, some still being litigated, is that the reason why people hate big tech really has to do with speech and with content moderation and with the language and the information, and depending on which side of that discussion you're on, whether or not that's fair or dangerous or representing views that are should be spread out to people. And that's a really hard problem to address through regulation. You know, we have done it in the past. I think of the fairness doctrine, for example, which is old these days, but it's really messy. And so people like to yell and scream about it and say how mad they are about it, but they're not really talking about an issue that I think the antitrust laws are designed to solve. And when I think about that problem, I think about effectively pipes. Fiona Scott Morton used to always say, is it, when we were talking about broadband, it's the wires into the home. Like how many wires, how many potential wires into your home can you have for broadband? And Chris, I'm not sure we've solved the broadband issue, by the way. I think the pipes access to effectively what are essential facilities, and that's another, you know, that's really what you want to think about in the antitrust world. Is someone doing something that's cutting off either access to a consumer or a customer that you need, or a group of customers that you need, or to customers writ large? Are they cutting off your access to a facility that you need to reach those people? So that's what net neutrality is all about, right? Are we going to make sure that the pipes are open for everyone and that everyone gets the same speed from the edge of the internet to into the consumer's home? And so I think to the extent we're going to see action in antitrust that's going to be successful, it's going to be in that kind of space. And again, you know, these are essential facilities, duties to deal. If you have been active in the antitrust world for the past 20 years or so, those are doctrines that have really been pushed. I was thinking, I was going to say beaten into submission by effectively the, I think the most successful administration at doing that was the Bush administration. You know, there was just, and this is, I think, in some way, the influence of the Chicago school to say, we don't want to get it in the way. We don't want to force people to have to deal with their competitors. We don't want to force those kinds of relationships on people. And you're going to have to find some way to roll that, I think, thinking back in order to make progress on some of those issues.
Right.
I have something super quick to say about the regulatory responses, and just to kind of have a little debate. I think the approach of saying where antitrust can intervene, we don't need regulation is not necessarily the right approach. So I think we need to think about antitrust and ex ante regulation as complementary in a variety of ways and as operating on the same market segments at the same time and doing things that might be similar or different. And there needs to be a lot more discussion on that.
Great. All right.
I thought she was supposed to be the lefty who was going to agree with me on this one.
Surprise.
Okay.
She kind of did.
Right, you know, a little agreement, a little disagreement. Okay, so this is interesting. So we heard Tim talk a bit about the internet's origin, and as Brad mentioned at our opening yesterday, you know, this conference is indeed ground zero for net neutrality. Renata just mentioned this notion of the pipes, right? The essential facilities. Today, the contemporary focus is on an open internet. So I want to ask our panel whether they think competition policy has a role to play in securing an open internet. And even before we get to that question, I'd like to know, how do we define it? How do we know when we have an open internet? What does that look like? And maybe moreover, is this a worthwhile goal, right? What do we have to give up in order to achieve that? And how do we know that this is the right thing to be striving for? So I'll start with Christopher.
So the first question, in all offense, Renata, it was about 40 years ago. So unless we were using broadband in the late 70s, it's a new problem, not solved.
Fair enough.
But anyway, so what's fascinating to me is, you know, does antitrust have something to teach us here, and is regulation the right frame? I think there's a critical difference, which is regulation, particularly as it's in the DMA and in the Klobuchar bill, really makes liability turn on structure and size. And antitrust traditionally looks at effects and conduct. And what we've learned over the years is that structure is a really imperfect measure of actual consumer welfare. In fact, we used to believe in it. We had this thing called the structure conduct performance paradigm that reigned in the 1960s until the 1960s, where we assumed structure necessarily implied certain conduct, which necessarily implied certain behavior and a market performance. And this is important because we couldn't actually measure market performance, and we couldn't actually measure price effects in these things empirically. And that sort of died along, not that long, a fairly short cataclysmic death. As a matter of pure economic theory, contestable markets tells us that large market share doesn't necessarily lead to bad performance when entry barriers are low. We learn from Stackelberg price leadership is that low market share doesn't necessarily lead to good outcomes, and certain market structures can be a problem. And that we moved away from this idea to actually looking at measuring the actual looking at conduct. Because in the old structured conduct performance paradigm, conduct didn't matter. It fell away as a variable of interest. It was just the structure was there. You don't have to know what you did on top of that. And if you look at modern monopolization doctrine through the rejection of the Neal Commission report, through the rejection of the Arita and Turner no-fault monopolization proposals in the 1970s, is we've consistently said that there's a problem there, which is ultimately success in large share is an ambiguous fact. It can be the result from successful competition on the merits. To quote Alcoa, if the successful competitor invited to compete eventually prevails, it can't be turned upon when it wins. So the problem is antitrust has traditionally looked for doctrines that separate outcomes that are the result of anti-competitive conduct, anti-competitive stuff that's inconsistent with competition on the merits and stuff that's consistent with it. And for that, we've always required the conduct element, which is essentially what's being taken away by the DMA and the Klobuchar bills. Is they look at the size, they look at the market, the number of subscribers you have, and that is inconsistent with this idea, the traditional notion of antitrust law. Now, to pick on the specific example that Hal gave, self-preferencing to me is ground zero. So you can look at a large firm and look at the practice and just say, okay, that's a problem, they can't do that. My colleague Herb Evenkamp has a riff on something that Elizabeth Warren did. Elizabeth Warren was really complaining about self-preferencing, and her targeted choice was batteries, old-fashioned alkaline batteries. This is dominated by Duracell and Eveready. And Herb picked up an Amazon private label battery and said, this is a half to a third of the cost of Duracell and Eveready. And he said, if you look at it economically, this category has the highest price cost margins of just about any consumer product. And so the idea that what he said, and I agree with, is that in this case, self-preferencing for private label goods would be immensely good for consumers. And without an analysis of actual effects in particular markets, you won't see that. And that in fact, we need to do. In fact, I used to, before I went to law school, went to business school, worked in branded products. Private label was the bane of branded products' existence. My wife did the same, worked in cereal. Gross margin in cereal is 55%. And you think that the Rice Krispies and the Cheerios you get in the bags from private label, they were killing them. And so it's one of these things where looking at the individual markets actually matters. Antitrust also has another lesson to teach us. This is per se illegality. You do that when you know the category well, you have a lot of experience with it, so you can draw the inference that categorically prohibiting it, you don't lose much. When you're inexperienced or it's complex or ambiguous, you do rule of reason. And again, that seems to be very much consistent with the antitrust paradigm. And to answer the direct question, it's how I've argued that I actually think an ex post case-by-case regime for network neutrality would capture the variations that we've seen in a world where the number of business practices and how we're delivering services to people via the internet is becoming incredibly heterogeneous. It's not an email and web browsing world anymore. It's 55% video, streaming video. And with Zoom and interactive video and all these intensive uses, smart homes, and you name it, it's demanding very different things in terms of clusters. A couple things, just really quickly. I'm not a fan, Renata, of curing cancer analogy, because in one sense, I say this as a person whose wife is a cancer survivor. Fortunately, it's something that's catastrophic when it happens, but it doesn't affect that many people, thankfully. Although, add for the moment, I found out that 1 in 8 women will develop breast cancer during their lifetime, so it's still a very, very high number. Things like Amazon that helped us get through the pandemic, or even not in a pandemic, just deliver services in a way that many people find more convenient, aren't large value, but they benefit far more people. And so in the grand calculus of how this all works, the question is that something that useful to frame it that way? I think you put your finger right on it when it's about speech versus economics. There's a long history criticizing the fairness doctrine, so I'm not crazy, which I'm happy to go into. But I do find us moving back and forth in that, which is people who are very upset about speech end up targeting companies based for economic concerns. Lastly, one thought about regulation and antitrust being complements versus substitutes. That's what Europeans think. They think they're complements. In a post-Trinco and where price squeezes don't work in the US, we think it's one or the other. Where basically that if you've got a regulatory regime, the antitrust falls away. And so in fact, it's consistent. It's a difference between the European system and the US system about how we view this.
Thank you.
So just one thing quickly. The reason why I think the curing cancer analogy is important is because I think Congress is spending tons of time talking about something that is really important to people, but there are many, many other issues and many, many other things that Congress could be doing that are like, involve life or death, funding education in the country, for example. And I feel like the tech companies are kind of like a convenient foil for them to talk about in order to avoid actually addressing some of the hardest problems that we have in the country. So that was the only reason why.
By the way, one quick thought for Tim on curing cancer. NIH is probably one of the best examples of industrial policy in the US.
I'd like to say a few things back to Christopher's point respectfully, because I think he got some things wrong about Klobuchar's bill, assuming we're talking about the self-preferencing bill. And that is, I think you said that it turns entirely on structure and a firm's size, and you're partially right in that you have no liability on the bill if you don't meet the size thresholds, but just having the size doesn't expose you to a finding that you violated the bill. It does turn on conduct. You do have to engage in self-preferencing. Someone does have to bring a case against you. So in that case, it is closer to case-by-case adjudication. The presumption is flipped from what a typical rule of reason is. It's not, the presumption now is going to be against the platform, whereas in antitrust cases, as you know, the presumption is in favor. It's the burden of proof is on the plaintiff to show. But it's some hybrid. So I think it's a little unfair to say that it's per se, and I think it's also unfair to say that it turns entirely on structure. There is a conduct element. You've got to, the plaintiff has to demonstrate that there was self-preferencing. And finally, Christopher used this example of Duracell, and I think that the example was probably chosen intentionally because none of us are going to lose any sleep over Duracell getting beat up. But you can imagine an independent merchant who's come up with an idea, not some titan of industry, but an independent who's come up with a good idea. And Amazon clones the product and then starts steering its searches to the clone. The problem, Christopher, I hope you can acknowledge, is that if enough independents kind of observe this cloning, observe this appropriation, and they realize that either I'm going to come up with a crappy product and die, or I'm going to come up with a good product and Amazon's going to clone it and die, then in future periods, a bunch of independents are going to start throwing in the towel. And that's the danger. It's that we want them to keep coming to the platform. You'd think Amazon would want them to come to the platform as well, but Amazon is internally conflicted in that they're trying to generate revenue growth in each quarter to satisfy shareholders. So I'm sure they understand the problem, but they err in the favor of appropriation, too much appropriation relative to the socially optimal level. So that's what we're trying to solve with that. And I'll just leave it at that.
So the only thing I would reframe, I actually do think it is penalizing size. If you think of the ban on self-preferencing not as an element of the offense, but the remedy being applied, then basically if you're a certain size, you have certain remedies applied to you, which is you can't do certain things as a business practice. And this is much clearer in the DMA, because if you hit the size threshold, you're subject to like 10 mandatory and another half dozen second order possible things where none of which are necessarily tailored to the particular case you're in. And they say maybe they won't apply all of them, but we still have to wait to see. And this is the lie on the idea that it's clearer to get rules in advance. There's still so much to be worked out in the DMA. But just thinking about the Klobuchar bill and ICOA, basically, if you have a size, you are subject to a remedy where you are barred from doing a certain business practice. And in that sense, it's not, you don't actually have a filter of anything else you need except for hitting those thresholds.
And I don't think you're quite barred, Christopher, because you can do it, of course, until someone brings the case, right? And then even after they bring the case, if you can demonstrate, if you can flip that presumption, you can continue doing it. So I don't think it's fair to characterize it as a complete and outright ban.
But again, well, we can have this argument, but anyway.
So
We'll go there.
can I actually answer your other question? The question that you began with?
Oh, yeah.
Which I do think competition policy has a role to play in the open internet. And we worked incredibly closely during the Obama administration with both the FCC and the White House on the open internet, and pushed very hard when I was at the antitrust division, pushed very hard for the open internet because we thought it was very, very important for competition. And we also worked incredibly closely with the FCC with Tom Wheeler and John Sallet on the Comcast Time Warner transaction. And, you know, we really, as we thought about it, and this is all public, the big issue that we saw there was the potential for that transaction to result in a less open internet, less access from the edge to the customer's home. So I do think there is a real role there.
And you remind me that one of the first hearings we saw on this was convened by then head of Office of Plans and Policy at the FTC, Maureen Olhausen, where Tim and I both spoke way back then. And it was the antitrust people were the first people to do that. I also remember testifying at a hearing on the Hill where the Judiciary Committee was fighting for jurisdiction with the Commerce Committees. And so that's a whole different level of this.
Yes.
Did you want to say anything on open internet?
I think I'll wait.
Can I just
I'll
get,
weave it into my.
can I just get one quick plug idea in for on the open internet before we leave the topic?
Yes.
Because I want to be on record as saying that I want to be on record as saying that I support it. But the question is, how do we get there? And I would like people to consider the idea of not trying to do this solely through the FCC, but instead through a legislative fix through Congress. I think that there would be vast support for a bill that did exactly what the most recent open internet order sought to do, but to do it through a different source of authority outside of Title II. I think that I think you would completely neutralize the telecoms attacks if you took it out of Title II. And because the policy is popular, I think it enjoys wide consensus among policy ranks. So I just leave it at that.
All right, thank you so much. So we'll keep on the topic, but I want to introduce another topic here. Many platforms today deal, for being honest, primarily in data. And many of us, when we hear data, immediately think privacy. But I think that Paul and Meg completely assuaged all of our concerns about big tech's privacy yesterday. So with that problem solved, we'll just put that aside for now and ask what competition policy might have to say about data collection and utilization. And Professor Bietti has done a bunch of work in this area, so I'll let her kick us off and then we'll open it up to the rest of the panel.
Okay, thanks so much. I was going to say, actually, I haven't heard perhaps enough about privacy and data at this conference, so I'm happy to compensate.
Because we solved it.
Right. So I wanted to say a brief thing which actually connects to what I'll be saying about data around the open internet. And a question is, what is the open internet? And I think, you know, when we think about the open internet, we think about having access to all sorts of services, no barriers to entry, being able to opt in and out very easily. But that also happens because companies are tracking us, because companies are taking something in exchange, and that could be data, it could be our attention, our behavior, whatever else we want to call it, but it's never completely free. And so I think when we talk about open internet, we also need to think about what's behind it. And so this brings me to the question of data, and I'll say three things. There's a lot to say about data and antitrust, but I'll limit myself to three. So the first is, what do we mean when we say data? And I think we're pretty confused. We think of it as an object. It's a set of ones and zeros. Particularly for privacy and data protection experts, data is an extension of the person. It embodies certain characteristics of individuals, or it materially represents populations, the relations between different people and different populations. And my view on data is that data is always the informational product of a context. So it acquires and reflects the shape, the functions, the purposes of those that collect it, of those that store it, process it, organize it, use it, right? And so I think that when we talk about data as an object that is out there, that is exchanged, that is shared, we're missing something. There's data all over the place, often when we don't notice it, often when we don't even see it. Okay, so secondly, so what have antitrust regulators been doing about data? So for a long time, they haven't been doing much about data. in the US and in many regions of the world, antitrust regulators have tended to dismiss questions of data and privacy as not relevant to competition analysis. So a salient example is the Google DoubleClick merger case, where the FTC decided not to investigate the case. And although they recognized that there were some privacy concerns attached to the merger, they expressly said that privacy was not, or data-related questions were not a competition concern. Today, things have changed, particularly in Europe, I must say. With the GDPR, I think there's been a huge kind of awakening to data as a phenomenon in Europe and for European regulators. And so antitrust authorities in Europe in particular have been really focusing on data as part of several cases, merger investigations like Apple Shazam, Google Fitbit, Facebook Gephi in the UK, and also a case that some of you might have heard of by the German Bundeskartellamt against Facebook, which basically held Facebook liable under antitrust for abuse of dominance because they had basically forced their users to consent to data collection across several business segments. And so the remedy that the authority imposed was the need to unbundle consent across different services. When you consent to data collection and use for Instagram, you're not consenting to data collection and use for Facebook, et cetera, or WhatsApp or whatever else. So cases of this kind have considered data relevant in at least two ways. So data has been considered a price equivalent quality factor relevant to competition analysis, and I can say more about this in Q&A. There's not a lot of time to elaborate. And then also data has been considered an element of market power. So being able to collect, control, use, process data does give a company more power on a given market segment than its competitors, right? So it provides market actors with more knowledge about their customers, about users, about their competitors themselves than other players on the same market. And it also allows them to have strategic knowledge that allows them to make purchases that might advantage them on certain market segments. And that was one of the allegations in the Facebook Gephi case, actually. And so these findings have led to a number of very interesting measures being considered and in some cases being imposed by antitrust regulators. And these include things like the unbundling of consent that I have mentioned, more opt-ins and opt-outs from data collection and data use and processing, data silos, which is something that was imposed in a couple of mergers where companies are asked to separate out certain databases relating to different services. There are things like data pools, data sharing arrangements. Data reuse is now a term that is being considered in Europe. So the reuse of data for public purposes. And more, there are possibilities for competitors to request access to certain databases or certain anonymized data. And so, you know, we could talk more about all this. I'll say, I think one of the goals of thinking about regulating data from a competition perspective is trying to separate out two things. So on the one hand, there are the rents attached to control over infrastructures, to control over essential facilities, pipelines, things that other competitors need to have access to. And then there's data that is processed, created through what might be called skill and labor, through particularly good engineering processes. And so that needs to be incentivized. Okay, and so a lot of my work has been about. And that's the fact that I think when regulators you know, we've come to a point where we realize that data is a competition concern, and we've come to the point where we have thought about several types of remedies. But ultimately what agencies, courts tend to end up with is with solutions that delegate more choices and more decision-making to users. So in the end, we always say, oh yeah, it's good for users to be able to decide to opt in or out of certain data collection schemes, certain data usage processes, etc. And I think what's missing is more thinking, and maybe that's really what goes to this industrial policy question as well, thinking more about who is making decisions on how data is collected, used, processed in the data economy. And we need less individualized, distributed, networked decision-making on these things, and a little bit more thinking about how groups of people, agencies, regulators, but also just individuals coming together can determine some of these questions.
Great, thank you so much.
So the way the US deals with data and antitrust, is probably the best developed in mergers. When data is a separate project, and like the Arbitron cases, it's actually pretty straightforward. It's just the same, you look at it, you understand you define your product market, your geographic markets, and you go. And that's pretty much unremarkable. What's really the more interesting problem is some stuff that Professor Bietti is talking about is when it's not a product in and of itself, but when it's an input into another product, which is the far more common use of data today. And actually, like a good academic, I've got a paper on this. Unfortunately, it's not ready. It's one of those in 80% done. This is not the first time we've looked at uses of input markets in merger analysis. There was a move in the 1990s to look at what we call innovation markets, where if you looked at R&D, another key input into innovative processes, if a company had a 10-firm industry, but the two firms that were merging controlled 90% of the R&D, should we analyze that as a separate market? And Rich Gilbert and Steve Sunshine came up with a really analysis of this, and it's very complicated. Not the least of which it has 5 fairly restrictive conditions. Just to throw a couple at them, actually, it's like 1, are all data fungible? In other words, could you just count up the amount of data in the resulting company and be concerned? And the answer to that is almost certainly no. R&D isn't fungible, it's along different lines, but the reality is, I've got a whole part of this is talking about the use of structured versus unstructured data and the roles they play in business models, and they're very different. In structured data, the scale economies are very small. And so this is something that's sort of overlooked. That's why I dislike the term big data, because it just encourages us to simplify and lump it all together with actually analyzing it in terms of a specific market. The other side is, supply side substitution is the basic one. A lot of the data that is the most valuable is used for advertising profiles, and that data is widely available from a wide range of sources. And so you actually have to grind your way through an analysis, even under the people who are proposing this in the R&D side, to actually figure out when it's going to happen. What's interesting is if you move, the bigger thing that Professor Bietti is getting to is beyond mergers, monopolization cases. And generally, if you go back to even cases like Philadelphia and National Bank, which we don't really think are good law anymore, but they said, hey, grow it yourself. And if someone grows it themselves through competition on the merits, generally monopolization under traditional law doesn't have a lot to say about it. And so what's interesting to me about California privacy law, it's really aimed at third-party transfer. Not only has it made it very hard for small and medium-sized enterprises to deal with the raw compliance, it's killed the data broker industry. So if you're not collecting it yourself, you really have fewer options. And it's not entirely clear that this is working out the way people intended. It is different in Europe. They have an essential facilities doctrine represented in the data space by a decision called IMS Health. The Supreme Court has had 3 chances to acknowledge this. It lives in many courts of appeals. It's never been endorsed by the Supreme Court, and many people think cases like Trinco kind of cut the other way. So we'll have to wait and see how that all turns out. The one thing I will say is the German Facebook case is a good example of the difference between the US and EU approaches to the relationship between competition law and regulation. They're basically saying Facebook, they're bringing them up on an antitrust case for violating privacy policies. There's a lot more to it, but it's pretty simple, in a simple form, that's one way to think about it. The way the US would think about this is probably, we have a privacy law regime designed to prevent violations. And the proper first order, by far first order response is to let that regulation apply. Now, is it possible that this systematic, you would have to affect markets before it becomes an antitrust problem. In other words, there's securities fraud. It doesn't, we go after the people who are defrauded, make whole the people who committed the fraud, we make whole the people who defrauded. But until you get to a systemic level effect, you don't do antitrust. And the worry I have about the German Facebook case is it's going to take garden variety privacy cases and turn them into antitrust cases with all the problems and the treble damages and you name it that kind of go along with it. And this is public enforcement, so that doesn't really apply, but even so, we have regimes that are fit for purpose for different things. And the question is, what the Trinko would say, we don't gain that much by overlaying antitrust on top of them if we have a functioning regulatory regime. And the idea there is to make privacy regulation effective and remediable.
Okay, thank you. Any short responses to that?
Yeah, I'll
Yeah.
try to make it short, but
Okay.
I wanted to weigh in on this one. And sorry, I have to have my glasses on because I just scribbled these notes, but I think the way to think about this question, let me just try to put a question to the audience, which is, can market forces be trusted, market forces driven by competition, to bring about the right level, the socially optimal level of privacy protection? I think that's the question that we have to grapple with. And I'll give you my answers, but you don't have to agree. But I think certainly under monopoly, the answer is no, right? We don't have the right level of privacy protection right now. That's obvious. But a harder question is, would we get the right level of privacy protection under perfect competition? Suppose we split Facebook, into 20 pieces, right? And I know I wasn't supposed to mention Facebook today. I'm sorry, handlers. Would we then get the socially optimal level of privacy protection? And even there, I'm skeptical. And if you're skeptical like me, then it seems like competition, while it's wonderful in many aspects, it may not be the elixir that we need for privacy protection. I think that argues in favor of some sort of regulation. And if I could just say kind of a shout out to something that Tim Wu said earlier today, I think this is almost like asking the question you're asking about how do we guide, what kind of questions or principles would guide our industrial policy? And let me submit, that we probably want to go to the places where we think the market is going to fail us. So I don't think that the market is going to generate the right investment, say, in green technologies. Dan doesn't like this answer. And so, right, because market private forces are not going to be able to capture all the benefits of cleaning up the environment. So this seems like an obvious place that government should be spending money in green technologies. And so the question that I just posed to you, I can pose it here. Can we count on market forces, even under competition, to induce firms to make the right level of choices with respect to pollution or carbon emission or green technology? I think the answer is no, we can't. Right, and for that reason, it's a good basis for government intervention.
Great. So before we turn to audience Q&A, which we will do in 2 minutes, I want to pose one last question to the panel for short answers only, and that's the quintessential Silicon Flatirons question of what's next, right? Any predictions for competition and the internet? Next big cases, what the policy is going to look like, what we should be focusing on. And I'll start with Christopher, and we can go down the line for anyone who has some thoughts.
A couple of quick predictions. One, the Klobuchar came close last Congress. It's dead this Congress. Jim Jordan has no interest or appetite for antitrust reform. And so it'll never hit the floor of the House. It just won't. And that is a change, and I think that means that in terms of doctrinal stuff, we're not going to see any changes. Second prediction is we're seeing this now. We have a judicial enforcement system, which I actually think is a good thing, but it does mean even if change were going to happen, it's going to take 10 years. Because you got to litigate it all the way up to the Supreme Court, because the lower courts are all bound, and they could write the opinions. I don't think this is true anymore, but the doctrine says this, and I don't get to overrule them until they say it's okay. And so the reality is the idea that no matter what happens, we're not going to see a lot of dynamic change coming out of the US. Although Lena Khan's trying a lot of innovative things in the FTC and Jonathan Cantor, so we'll see.
All right, thank you. Elettra.
So I think, so yesterday we've been talking about the US and other regions of the world, and it's really interesting that there are different things happening in different places. In general, I think we're moving towards a time when we are recognizing that the digital economy is becoming a regulated industry. Now, I think there are several questions about that. What kind of regulated industry? Is it going to be several different little regulated industries depending on what companies are active in and how their services will be regulated? So for example, speech services, content-based services, attention platforms might become a very separate kind of economy. But we're certainly moving towards a climate for more ex-ante, preemptive, structural intervention in digital markets. And I'm a supporter of that, and I think that's great. I had something else to say, but I forgot, so I will leave it here.
All right, thank you. Al?
I wasn't prepared for prediction. I think it's probably dangerous for me to make a prediction. So I'm gonna pass and wait for another question from the
All
audience.
right. And finally, Renata, any thoughts?
I mean, I think we are going to see a different landscape. I'm not sure if the companies will be different or if what they're doing will be different. I do think these industries, I think they are dynamic regardless of what people like to say. And I think they do change, and they change relatively rapidly. So I think we may be talking about different kinds of issues. AI is a big one that we'll probably be talking about going forward. And what the impact of AI is, for example, on the world. I don't know. It's going to be, but I think it's going to be different. I think we're going to see some change.
And you can join us in April to talk more about AI. Yes, audience Q&A.
Student first.
Student. Are there any students in the audience with a question for our panelists?
Yeah, I'll go for it because I have the mic.
Excellent.
Oh, I'll stand up too. Hello, Dr. Tuel introduced myself yesterday, and my antitrust professor is not in the room, so I feel a little safer asking this question. Talking about potential antitrust action against Amazon, which has been in the news as the FTC is investigating. How does it complicate the analysis talking about looking for harms in the sense that for every person who suffers from Amazon Web Services establishing some guarded walls, the average American consumer who wants to buy like one of 5 different silicone spatulas on the marketplace still is like appreciative of the ability to buy those 5 different ones? I think it's kind of a curious, like, I'm not sure how to work out the difference in those harms where you have people on the marketplace who suffer for the strictures of the marketplace, but then consumers who just want to purchase from Amazon or watch a movie don't suffer those harms. How does that affect the analysis?
Go to a slightly different shopping case. One of the best ones we have is the comparison shopping case against Google, which was led to the second largest multi-billion-dollar fine in history in Europe. In the US, you look for a metric that separates whether it's good for consumers or bad for consumers. And in that case, it was a click-through on its transactions. If you have a different way of distributing and more people buy, that's a very generally regarded in antitrust law, a very good indicator that this is probably creating benefits. Now, it's not dispositive. You could be delivering more value to a smaller number of customers. But we saw this in the Uber case in the Third Circuit, where they were actually looking at the taxi cabs brought an antitrust case against Uber. And if you think about the irony of that, just enjoy that for a little bit. And the judge said, there are more rides now than there were under taxis alone. You lose. And so this is the thing antitrust law does, is it looks for filters that try to identify when it's going to be good for consumers, when it's bad, and try to use those to separate different conduct, which is, you can tell good stories about and bad stories about, but you really want to know how to settle it, and that generally requires some sort of empirical evidence and test.
Can I answer? Because the question was consumer-centric, and Christopher took a jab at the structured conduct performance paradigm, so I'm going to take a jab at the consumer welfare standard, which I think, if I had to make a prediction, I was 5 minutes late to my prediction, but now it's that I think consumer welfare might not be the way that governs the future of antitrust, as evidenced by, for example, the DOJ's challenge of the book merger, the book publisher merger. It was not about consumers there at all. It was about the writers, which was really energizing to see that other actors in the economy could actually be represented and cared for outside of consumers narrowly. And so what I would tell the student, if he's still listening, is, the two theories of harm that I just laid out, the principal injured party in both of those is the merchant, right? And I understand that you've probably been so indoctrinated in the consumer welfare standard, it's hard to think about how anyone could matter besides consumers. But I think that if the plaintiff could demonstrate that merchants have to pay, say, a higher take rate on Amazon because of the most favored nation clause, that is, in the absence of the MFN, the merchant would try to steer users outside of Amazon to a lower cost platform. That in turn would cause Amazon to have to reduce its take rate, right? That's an injury to a merchant that might be cognizable under antitrust as it's going to be practiced going forward.
Great.
Tim had a question. I know, but I don't know if you saw him. He's the VIP. Go ahead.
Hi, thanks for calling I wanted to make a comment and then ask a question. Well, just the comment first is that, yeah, I certainly agree Microsoft belongs in the trilogy of sort of industrial policy like antitrust decisions. And I have long felt that there's a very important sense in which most of the giants today owe a lot of their continued existence or vibrancy to the Microsoft decision. I don't think it was out of charity that Microsoft allowed Explorer to be a launching pad for so many other companies. I think they were under scrutiny, which does get something that Christopher, you said, there's this question, antitrust does take a long time. One of the interesting questions is whether in the course of antitrust investigation, there is an effect on conduct, the so-called policeman at the elbow effect. So, IBM was under pretty intense scrutiny for 13 years and by the Justice Department. During that key period, actually, when Microsoft, to bring them back, was being created, one day, once I cornered Bill Gates and asked him, that period when, IBM was, you're doing these deals, it's like, I was very surprised they didn't kill us or buy us. And, it's hard to know exactly, but there's this kind of moment where they're like, I don't know if we buy out Microsoft or kill IBM, do they end up with new antitrust problems? So there's some effect there. I'm not going to say it's everything. And maybe today's tech platforms are more inclined to just ignore the case and throw their lawyers at it. But I think sometimes, some of you on this panel are lawyers or counsel to companies and maybe would know more as to whether that affects conduct. Unfortunately, I did have a question. Sorry, I don't want to go on forever. But I think it's up for grabs what antitrust is for right now. I agree with Hal that cases like the NCAA case and also the Random House case suggests a different story here. And I guess this is a question for Renata in a sense. You were talking about the sense in which they'd have to return to some of the rules that overcome what you can call the Colgate presumption, or more specifically, the sort of natural right of a business not to deal with anyone else, force them to deal with others. That, to my mind, is, I guess, what I'd call the rules of the road approach to antitrust. It's more interested in sort of a competitive process as opposed to strictly focused on, can you show a cognizable harm to consumers? And so I guess the question, maybe this is for the whole panel, is whether if antitrust takes that more rules of the road approach, do you think that is a desirable direction for it to go in terms of, I guess we're talking about the internet or antitrust in general? And is it really so perilous? That's, I guess, what I want to ask her. Anyway, your opinion on going to sort of more rule of the rose, competitive process style of antitrust. Thank you very much.
So I'll jump in. I actually am not a big believer in the rules of the road form of antitrust, because I think it causes antitrust enforcers in particular to feel too constrained in terms of what they can do. And I know that, Bill Bearer and I, during the Obama administration, really spent a lot of time talking to people about, don't tell me what doctrinal box this fits into. Tell me what's happening, who's being harmed, how are they being harmed, and what's the competitive mechanism that's creating the problem, and how do we fix it? And I really think that's the best role for antitrust. I think that's how we should think about it. Because when you start, the boxes can be very convenient and they can be very helpful in terms of, particularly if you're counseling companies, telling them, well, this looks like it's this kind of case and these are the kinds of things you should be concerned about in that kind of case. But when you're thinking about particular either conduct or transactions, it's really important just to think about what's really going on and how to explain that to someone, particularly if you're thinking about a lawsuit, whether you're the government or a private party. Because I find sometimes people get too bollocksed up in trying to fit things into these doctrines, and courts have lists of factors. And I think that's part of what happened to Epic in the Apple case. They were just too hung up on the law as it was written down, and the law about single brand submarkets. And I just think the court didn't really understand what the problem was exactly. And I think the opinion reflects that, so.
So what's ironic to me is Brandeis himself did not like rules of the road. He took them all out of the FTC Act, and he went to a more effective. It's just one of those interesting. I'm doing some work on the historical roots of Brandeis. Brandeis is a thought, and it's fascinating. But what I would say is the one thing I worry about, and to some extent, I'm moving away from the consumer welfare standard. You risk protecting competitors, not consumers, and inefficient ones at that. And so one of the things my takeaway, and this involves the network neutrality issues and something I'm sure Hal will disagree with me on, but the learnings we have over vertical integration over the years is that the vision of which each leg maximized its choices was actually a bad way to organize certain industries. The way I teach my students, in Toyota in Japan, there's a thing they call Toyota City, where there's a bunch of parts manufacturers who only make for Toyota. And the question is the car industry uncompetitive? And the answer is, as long as you have enough, even if they're all vertically integrated, if you have enough brands of cars, inter-brand competition will be fine. And that the teaching of vertical integration, the last 50 years of the economics of this, is that this is often, and the empirical evidence backs it up, it tends to be at worst neutral and like 90+% of the time neutral or beneficial. And so a reflexive hostility towards it, and this is done by Francine LaFontaine and Margaret Slade, one of whom was the chief economist during the Obama administration, the later half, said, we didn't expect this result when we went to this survey of the literature, but if the inferences are there, categorically banning things because of these, if it's possible outcomes, you go to the empirics. And they came to the conclusion that it was not appropriate. I know there's a lot of people there's a lot of academic discussion about the consumer welfare standard. I have my own opinions on that, but what I would say as a purely descriptive matter, in a judicially driven system, without new legislation, it's going to be the Supreme Court, and this court does not seem likely to overturn that standard. So as a matter of pure prediction, NCAA is actually one of the cases that explicitly cites the consumer welfare standard and adopts it. But we're reading the cases. But even regardless of what the cases say, my prediction is that this court won't. And I've heard other people make it, and I've heard other people disagree with me too. So, and we all know that predicting what the Supreme Court is going to do is extremely hazardous business at best. But let me put it this way: it's in their hands. And if you think that's going to change, it's going to largely turn on your belief on whether they're likely to abandon the standard.
Thank you. Who couldn't talk about antitrust all day, really? But our time has come to a close. Please, let's take this conversation to our break. I'll turn it over to Blake for instructions.